Over the last few weeks, hundreds of international students have quietly faced a hidden administrative crackdown on campuses across the country, including here in Champaign at the University of Illinois. These students, often unaware until it's too late, have had their SEVIS records, the central component of their immigration status, terminated under vague and undisclosed justifications, commonly described as identified in criminal record checks. But this broad categorization disguises a troubling truth. Many affected students have no meaningful criminal history at all, having only traffic violations, dismissed charges, or even incidents never formally charged. Worse still, the procedural safeguards supposedly protecting these students have been neutralized at the very institutional level intended to assist them. In theory, our immigration system provides clear steps for international students whose SEVIS status has been wrongly terminated. If a student's SEVIS record is terminated, federal regulations explicitly allow the student's designated school official, a university employee certified by the government, to issue a reinstatement I-20, enabling the student to formally challenge the termination before U.S. Citizenship and Immigration Services. This is not a controversial remedy. It is a basic due process measure built directly into the law. It allows students their day in court, or at least their moment before an impartial adjudicator. Yet the University of Illinois, like many institutions nationwide, has informed affected students that it cannot provide the required reinstatement I-20s. Here lies the hidden crisis. The federal government, through the Student and Exchange Visitor Program, is quietly pressuring DSOs to withhold these critical reinstatement forms. By doing so, the Student and Exchange Visitor Program has effectively turned DSOs, university employees, into gatekeepers of immigration enforcement. This move denies students not just the formal avenue of challenging their SEVIS terminations, but also the fundamental right of due process itself. How could DSOs become unwitting enforcement agents of immigration policy? The answer appears to lie in the program's implicit threats of institutional decertification. DSOs are understandably cautious. Their universities rely heavily on international students, and student and exchange visitor program certification is the lifeblood of that relationship. No university wishes to risk its own certification. The result is silent complicity. Universities avoid openly confronting program policies or publicly disclosing the threats or informal directives they're receiving. Instead, they quietly tell students, "We cannot help you." But this silence and compliance represent exactly the moment when courage and clarity are most needed. The DSOs and their university leadership now occupy the decisive moral ground. They alone hold the power to expose the procedural sabotage occurring beneath this seemingly mundane administrative action. If they choose to speak openly, they can illuminate how the Student and Exchange Visitor Program's unofficial directives have overridden transparent legal processes. If they remain silent, they become complicit in denying students basic due process. We therefore issue this call clearly and directly to university DSOs. First, acknowledge publicly the explicit or implicit instructions received from the government that prevent issuance of reinstatement I-20s to terminated students. Second, assert your institutional autonomy by issuing reinstatement I-20s to students who request them, allowing USCIS to adjudicate the validity of terminations openly and transparently. Third, demand clarity from DHS and the Student and Exchange Visitor Program regarding the legal rationale for these terminations and seek written guarantees that universities will not face retaliatory loss of certification simply for enabling due process. University administrators often speak eloquently about values such as fairness, transparency, and respect for international diversity. But if these values hold meaning, they must be defended at precisely the moments when due process and transparency are most threatened. The crisis we now face is not merely administrative, it is ethical, legal, and deeply moral. DSOs and university leaders, through their actions or their silence, are now positioned to decide whether American campuses remain places where justice is protected or where it is quietly extinguished. There's still time for universities, starting here at the University of Illinois, to set a national example. By issuing reinstatement I-20s despite pressure, universities could force DHS into the open, restoring due process and accountability. At the very least, universities owe transparency to their students and communities. Speak clearly, publicly, and truthfully about the pressures exerted by the government agencies. The current wave of arbitrary visa revocations and the coerced complicity of universities cannot withstand the clarity of public scrutiny. DSOs, we urge you, reject the quiet role you've been forced into, reclaim your autonomy, and speak openly. It is not only your students who depend on you, it's also the integrity of the educational institutions we all value deeply.